The Israeli-Palestinian conflict, messy, complicated, and seemingly endless, boils down to one loaded question. Who does the land actually belong to? Forget the headlines. Let's look at the legal receipts. Who has the paperwork? Who has the claim that would stand up in court? We're diving into the legal arguments, especially from the Palestinian perspective. This isn't about picking sides, it's about understanding the case. We'll examine treaties, UN resolutions, and historical documents to see what the legal case for a Palestinian state looks like. On one side, Palestinians claim centuries of continuous presence and cite international agreements promising them sovereignty. They point to documents from the Ottoman Empire, the British Mandate, and the United Nations, arguing their right to self-determination was recognized, then ignored. On the other, Israel's legal argument draws from ancient ties and modern international law, like the Balfour Declaration and the League of Nations Mandate, claiming a legal right to a national home. Both sides use historical documents and legal interpretations to make their case, like two people showing up with deeds to the same house. This legal question is the foundation of the entire conflict, shaping negotiations, settlements, refugee rights, and borders. Understanding these arguments helps us see past the noise to the core principles at stake. So buckle up, we're about to unpack the legal briefs. Let's start with a quick history lesson. How did we get here? To understand the legal fight, you need the history. For centuries, the land was part of the Ottoman Empire, no country called Palestine, just a region with mostly Arab residents and a small Jewish community. These people were Ottoman subjects with land deeds and taxes, an established indigenous population. World War I changed everything. The Ottoman Empire collapsed and Britain took over. In 1917, the Balfour Declaration promised a Jewish national home in Palestine, but also not to prejudice the rights of existing non-Jewish communities. One document, two promises bound to cause problems. The League of Nations gave Britain the mandate for Palestine, tasking them with implementing the Balfour Declaration while protecting local rights. Palestinians argue this violated the right to self-determination, a core League principle. Article 22 of the League's covenant said former Ottoman territories should become independent nations. Palestinians say, "That was us. Instead, we got colonized." In 1947, Britain handed the problem to the UN, which proposed dividing Palestine into two states, one Arab, one Jewish, with Jerusalem as an international city. Jewish leaders accepted, Arab states and Palestinians rejected, arguing the UN couldn't partition a country against the wishes of its majority. They saw it as giving away more than half their land to a minority. This rejection led directly to the 1948 war and the creation of Israel. The legal and political mess only deepened from there. Now let's look at the core Palestinian legal argument. The Palestinian legal argument centers on two ideas: self-determination and the inadmissibility of acquiring territory by force. Self-determination is a core principle of international law, enshrined in the UN Charter. Palestinians argue they were the overwhelming majority in Palestine at the end of the Ottoman era and during the British Mandate, so they had the right to decide their own future. They point to Article 22 of the League of Nations Covenant, which made the well-being of these peoples a sacred trust. Partitioning their land and facilitating mass immigration without their consent, they argue, violated that trust and their rights. After the 1948 and 1967 wars, Israel took more territory. Palestinians, backed by UN resolutions, call this an illegal occupation. Land can't be kept by force. Their case: we were here first, you can't give our country away, and you can't keep what you took by war. Palestinian lawyers rely on key documents. The UN Charter's Article 1 enshrines self-determination for all peoples, which they say applied directly to them as the indigenous majority. The 1947 partition plan, they argue, was only a recommendation and couldn't override their rights without consent. The Fourth Geneva Convention, especially Article 49, prohibits an occupying power from transferring its population into occupied territory, making Israeli settlements illegal under international law. UN Security Council resolutions 242, 446, and 2334 all reinforce that the occupation and settlements have no legal validity. The 2004 International Court of Justice advisory opinion declared the West Bank occupied and the settlements illegal. While not binding, it's the most authoritative legal statement on the issue. For Palestinians, these legal opinions are a massive victory. Their case is built on international law, not just emotion. The Israeli legal argument is rooted in a different framework. Israel points to the 1920 San Remo Resolution and the League of Nations Mandate, which they say created a binding obligation to establish a Jewish national home. They argue the mandate's territory included what is now Jordan, and that the West Bank is not occupied but disputed, since Palestine was never a sovereign state. Israel claims it took the West Bank from Jordan, which had no legitimate claim. On settlements, Israel argues the Geneva Convention's ban on population transfer was meant to prevent forced genocidal transfers, not voluntary movement into non-sovereign territory. Israel also cites security needs as legal justification for its actions. Their case historical claims a unique reading of occupation law and national security. What do legal experts say? The consensus is clear. The West Bank is occupied territory and the Fourth Geneva Convention applies. John Dugard, former UN Special Rapporteur, calls it occupied territory, not disputed. The International Committee of the Red Cross and most legal scholars agree. Israeli settlements violate Article 49 of the Geneva Convention. Even Israeli legal advisors have acknowledged this in internal memos. There are dissenting voices like Professor Eugene Kantorovich, who argue the settlements aren't illegal and that the West Bank is non-sovereign territory. But the International Court of Justice, in a 14-1 decision, reaffirmed the occupied status and illegality of settlements. The lone dissent was from the U.S. judge. The legal answers are clear. The problem is enforcement, not ambiguity. The debate is less about law, more about political will. Let's put the legal arguments side by side. Palestinians emphasize self-determination and continuous presence, citing the UN Charter and Geneva Conventions. Their case inherent rights violated by colonial powers and the UN. Israel starts with the Balfour Declaration and Mandate-era documents, arguing for a legal right to a national home. Their case no Palestinian state ever existed, so the territory isn't occupied in the legal sense. The disagreement over occupation is central. Palestinians see Israel as a belligerent occupant. Israel calls it disputed territory. Ultimately, it's a clash between the right of an indigenous people to self-determination and the right of a people to a national home granted by international instruments. Both sides believe international law is on their side, but they're reading from different chapters. This fundamental disagreement shapes everything that follows. Why does this legal debate matter? Because it shapes real lives and future peace. If the West Bank and Gaza are occupied, Israel has strict obligations under international law. Settlements, the separation wall, and home demolitions are judged by these standards. The legal framework each side adopts defines what's negotiable in peace talks. The Palestinian Authority has joined the International Criminal Court, which is investigating alleged war crimes, relying on the legal status of occupation. For Palestinians, international law is a tool for legitimacy and leverage. For Israel, challenging the legal consensus is about legitimizing its actions. The legal battle is for the moral and legal high ground, and the future of the region. So are Palestinians the legal owners? The answer isn't simple, but the dominant interpretation of international law strongly favors their case. Self-determination, the ban on acquiring territory by force, and the Geneva Conventions all weigh heavily for Palestinians. The consensus from the ICJ, UN, and most legal scholars is that the West Bank is occupied and settlements are illegal. Israel's legal case is a minority view, built on mandate-era documents and a unique reading of occupation law. But legal ownership isn't the same as actual possession. Without political will, the law remains theoretical. The Palestinian case is a powerful testament to their claim, but enforcement depends on global politics. This debate is about more than land. It's about rights, justice, and whether international law applies equally to all. Until the legal question is addressed justly, lasting peace will remain elusive.